Joe McCann walked off a plane in the United States on May 4th, 2025. His passport had been returned. His attorney released the statement. No arrests had been made, no charges filed. The fiancé of social media influencer Ashlee Jenae, dead less than a month earlier in a luxury resort halfway across the world, was home. And the internet erupted with one question. How? I want you to sit with that for a moment, because what we're about to examine isn't whether Joe McCann is guilty of a crime. That determination belongs to a court, and no court has made it. What we're examining is whether the physical evidence, the timeline, the investigative actions, and the documented facts support the conclusion that this case is closed, that McCann has been cleared, that the official ruling of suicide is forensically sound. And I'm going to show you why the answer to that question depends entirely on which definition of cleared you're using. There are three definitions, and they are not the same. This is Crime Case Analyst, and this is not a recap. This is a forensic breakdown of what happened when a 25-year-old woman died in paradise, and the man she travelled with came home, while her family is still waiting for answers. Before we go further, if this kind of deep forensic analysis is what you're looking for, make sure you're subscribed to Crime Case Analyst and notifications are turned on. This case is evolving rapidly, and the next development could change everything we think we know. Let me start with what we know for certain. On April 9, 2025, Ashlee Jenae Robinson was found unresponsive in her villa at the Zanzibar resort on the island of Unguja, Tanzania. She was 25 years old, a content creator, an influencer with thousands of followers who documented her life in real time. She had travelled to Zanzibar with her fiancé, Joe McCann, for what was supposed to be a romantic getaway. She never came home. The Tanzanian police force issued a statement on April 13th. They classified her death as suicide by hanging. They said the investigation had been completed. They said there was no evidence of foul play. 4 days later, on April 14th, Commander Mambosasa, head of the Zanzibar police, gave an interview confirming that forensic examinations involving the head of the deceased were still ongoing. Let me repeat that. The investigation was officially closed on April 13th, but forensic examinations on the victim's skull were still being conducted on April 14th. That sentence alone should tell you everything you need to know about the timeline we're dealing with. A police force does not continue forensic examinations on a victim's head after officially ruling the death a suicide. Those two actions are contradictory. And that contradiction is where this case begins. So let's talk about what cleared actually means. In legal terms, no charges filed means the prosecutor has determined that, at this time, the available evidence does not meet the threshold required to bring charges. That threshold varies by jurisdiction. In Tanzania, under the Criminal Procedure Act, the Director of Public Prosecutions must certify that there is sufficient evidence to support a conviction before charges can be filed. That certification has not been issued. But that doesn't mean the evidence doesn't exist. It means the decision has been made not to pursue charges based on the evidence currently available to, or being disclosed by, the investigating authority. Now let's talk about investigative clearance. When a person is questioned as a witness and then released, that does not mean they have been cleared of involvement. It means the evidence threshold for arrest has not been met at the time of questioning. Witnesses can be recalled, evidence can be re-examined, charges can be filed later, even months or years later. Joe McCann was questioned by Tanzanian police. His passport was seized. he was not permitted to leave the country for approximately 3 weeks. Then his passport was returned and he was allowed to leave. His attorney, Edward Andrew Pulsick, emphasized in a statement to TMZ that McCann was never arrested, never charged, never named as a suspect. He was questioned as a witness. All of that is true. But here's what the attorney did not say. He did not say McCann has been cleared of involvement. He did not say the investigation has concluded. He did not say McCann is no longer a person of interest. Those are not small omissions. Defense attorneys choose their words with surgical precision. Not arrested describes a legal status. Not charged describes a prosecutorial decision at this moment in time. But cleared is a statement of evidentiary conclusion, and no attorney representing someone questioned in connection with a death will use that word unless the investigation has formally, publicly, and definitively closed with a finding of no involvement. That finding has not been made. So when the public hears Joe McCann has been cleared, what they're actually hearing is Joe McCann has not been charged. And those two statements are not synonymous. Now let me take you back to the beginning of this trip. Because the forensic timeline doesn't start on April 9th. It starts 4 days earlier. Ashlee and Joe arrived at the Zuri Zanzibar on April 5th. Multiple sources, including CBS News and 6ABC Philadelphia, have confirmed that resort staff documented escalating conflict between the couple during their stay. The nature of that conflict has not been made public, but the result of it has. By April 8th, 1 day before Ashlee's death, resort staff made the decision to separate the couple into different rooms. Think about what that means. Luxury resorts do not intervene in guest disputes lightly. Staff are trained to be discreet, to avoid confrontation, to prioritize guest experience. For staff to make the operational decision to physically separate two guests who arrived together as an engaged couple, the conflict must have been significant enough that staff believed it posed a safety or liability risk. We don't know what Ashlee said. We don't know what Joe said. We don't know if the decision was made at the request of one of them or imposed by management. But we know it happened. And less than 24 hours later, Ashlee was dead. Here's what we know about the morning of April 9th. A staff member discovered Ashlee unresponsive in her villa. The official ruling states she died by hanging. Police were called. The scene was photographed. But here's what didn't happen. The scene was not preserved as a potential crime scene before the body was moved. No independent forensic authority outside of the Tanzanian government has confirmed conducting a crime scene reconstruction. The physical evidence, the ligature, the position of the body, the condition of the room, was documented by local police and only local police, and that matters. Because in any suspicious death, the scene is the most important evidence source. It tells you what happened in the moments before death. It tells you whether the physical evidence is consistent with the official narrative. It tells you whether what you're looking at is what it appears to be, or whether it's been staged. The family has not been given access to crime scene photos. They have not been given a reconstruction report. They have not been told what the scene looked like when staff first entered the room. What they have been told is that their daughter is dead and the investigation is closed. Let me take you through what happened in the hours after the discovery. Joe McCann contacted Ashlee's family. According to the family, he told them Ashlee was at the hospital and that she was okay. That phone call happened hours before the family was officially notified of her death. Now, McCann's attorney disputes the family's characterization of the communication gap. Palcic told TMZ that McCann texted Ashlee's mother, Yolanda Endres, on April 9th, and that she never replied. The family has not publicly responded to that specific claim. But here's what we know for certain. There was an 11-hour gap between when Ashlee was discovered unresponsive and when her family was told she was dead. 11 hours. In that window, her body was moved, evidence was collected, statements were taken, and the person who had been with her, who had been separated from her by resort staff the day before, was the primary source of information about what happened. Let me talk about the autopsy, because this is where the forensic record and the official narrative begin to diverge in a way that cannot be reconciled. On April 13th, the Tanzanian police force issued a press release stating that Ashlee Jenae died by suicide. The investigation, they said, was complete. One day later, April 14th, Commander Mambosasa confirmed in a public statement that forensic examinations involving the head of the deceased were still ongoing. I need you to understand what that means forensically. In a hanging death, the autopsy establishes the mechanism of death. It documents the angle of the ligature mark on the neck. It identifies fractures to the hyoid bone, a small bone in the throat that breaks in specific ways depending on whether pressure was applied from above, from the front, or from suspension. It documents petechial hemorrhages, tiny burst blood vessels in the eyes and face that indicate oxygen deprivation. It examines the cervical vertebrae for damage consistent with a fall or suspension. All of these findings distinguish a self-inflicted hanging from manual strangulation staged to look like a hanging. The family has stated publicly, through multiple news outlets including 6ABC, that they are still waiting for the complete autopsy report. As of early May, they have not received it. So, the suicide ruling was issued before the forensic examination of the victim's head was complete. That is a documented fact, and it means the conclusion was reached before the evidence required to support that conclusion existed. That's not an investigation. That's a predetermined outcome searching for validation. Now let me show you what's missing from the evidentiary record, because what's absent from this case is just as significant as what's present. The Zuri Zanzibar resort has surveillance cameras. Harry Robinson, Ashlee's father, confirmed this in an interview with 6ABC. He specifically requested that the footage be reviewed by an independent authority. As of now, no independent entity outside the Tanzanian government has confirmed reviewing that footage. No stills have been released. No description of what the cameras captured has been made public. That footage would show who entered and exited Ashlee's villa in the hours before her death. It would show whether she was alone. It would show the movements of resort staff, of Joe McCann, and of anyone else present on the property that night. It is the single most important piece of evidence in this case, and it is sealed. Ashlee's phone has not been returned to her family. Her passport has not been returned. Her engagement ring, reportedly worth thousands of dollars, has not been returned. None of her personal belongings made it back to the United States with her body. Think about that. In a death investigation, the victim's phone contains the most complete record of their final days, text messages, social media activity, search history, location data, deleted content. It is the victim's digital testimony, and it's missing. The family has not been told whether the phone was recovered at the scene, whether it's being retained as evidence, or whether it was never found. The absence of that explanation is forensically significant, because if the phone was at the scene and it's being retained, that suggests the investigation is ongoing, which contradicts the official closure. And if the phone was never recovered, that raises the question of where it went and who had access to it before police arrived. Let me tell you about the people who were questioned. Approximately 10 individuals were taken in for questioning by Tanzanian police in the days following Ashlee's death. That includes resort staff. That includes Joe McCann. And that includes a foreign friend of McCann's who was also present in Zanzibar at the time. That friend has never been publicly identified. Their role in the trip has never been explained. Their presence in Zanzibar, at the same resort, at the same time, has never been addressed in any official statement. But they were questioned by police, and then released, just like everyone else. Not one statement from any of those 10 individuals has been made public. Not one witness account has been independently verified by a source outside the Tanzanian government. The people who had the most access to the scene, to the victim, and to the timeline before police arrived have not had their testimony subjected to any kind of independent forensic analysis. That's an evidentiary black hole. Now I want to examine Joe McCann's public statement, because what he said and what he didn't say tells us a lot about the strategy behind his silence. On May the 5th, McCann posted a statement on X. It was his first public comment since Ashlee's death 26 days earlier. Here's what he wrote. "There are no adequate words to describe the total devastation, emptiness and shock I feel after losing my best friend, confidant and fiancée, Ashlee Jenae Robinson." He goes on to describe her character, her compassion, her desire to become a mother. He calls her an angel. He says he will love her forever. It's a eulogy, and it contains not a single fact about what happened. There is no timeline, no description of the trip, no mention of the conflict, no mention of the room separation, no explanation for the 11-hour notification gap, no account of the discovery, no statement about his cooperation with investigators. In forensic statement analysis, we pay attention to what is absent from a statement just as much as what is present. And what is absent from Joe McCann's statement is anything that could be verified, cross-referenced, or contradicted by evidence. That is not an accident. That is a strategic document designed to establish emotional alignment with the deceased without providing information that could be forensically examined. And then there's the language. McCann uses the word loss twice. Unfillable void left by Ashlee's passing. Unfathomable loss. Loss is a passive word. It describes something that happened to the speaker, not something caused by someone. Contrast that with the language families typically use when they believe a loved one was killed. Taken from us, stolen, murdered. Those words assign agency. Loss removes it. I'm not saying this language proves anything. I'm observing that the construction of McCann's statement, passive language, no factual account, subject separation between the public persona and the private person, is consistent with a statement designed to be emotionally sympathetic while remaining forensically untouchable. His attorney promised there would be more to say at the appropriate time. That time has not come, and until it does, the public has a eulogy, but no answers. Now let me show you what Ashlee's family has done, because their response is just as forensically significant as McCann's silence. Harry Robinson told 6ABC he wants the surveillance cameras reviewed. He wants the autopsy completed and released. He wants his daughter's belongings returned. He wants answers. Yolanda Endres, Ashlee's mother, has not made accusatory statements. She has not named Joe McCann as a suspect. She has not publicly declared that her daughter was murdered. What she has done is document specific, verifiable gaps in the investigation. The missing phone, the missing engagement ring, the incomplete autopsy, the sealed footage. This is not the behaviour of a family in denial. This is the behaviour of a family conducting their own parallel investigation because the official one has not produced evidence that aligns with what they've been told. And then there's the funeral. The family prohibited Joe McCann from attending Ashlee's funeral. That is a documented fact, confirmed by multiple outlets. Families ban individuals from funerals for many reasons. But in cases where the death is suspicious and the investigation is ongoing, a funeral ban sends a very specific message. The family has seen or been told something that makes them unwilling to have that person in the same room as the deceased. I'm not saying that proves McCann's guilt. I'm saying the family's decision reflects their private assessment of the evidence, and that assessment does not align with the official conclusion. So let me bring this all together. A 25-year-old woman travelled to a luxury resort with her fiancé. 4 days of escalating conflict were documented by staff. The couple was separated into different rooms for safety reasons. Less than 24 hours later, she was found dead. The official ruling was suicide, issued before the autopsy was complete. Her belongings were never returned. Her phone is missing. The surveillance footage is sealed. 10 people were questioned, none charged, none publicly cleared. And the fiancé has returned home with a statement that contains no facts, an attorney who promises more information at the appropriate time, and a passport that was seized and then returned without any public explanation of what changed. This is not the footprint of a closed case. This is the footprint of a case where the conclusion was issued before the evidence was collected, where the evidence that could validate or contradict that conclusion is controlled by entities with institutional incentives to maintain it, and where the person most likely to have information about what happened has provided no verifiable account of what happened. Joe McCann has not been charged with a crime. That is a fact. Joe McCann has not been forensically cleared of involvement in Ashlee Jenae's death. That is also a fact. And the distinction between those two facts is the space where this case lives and where it will remain until the evidentiary gaps are filled by someone other than the people who benefit from leaving them open. The forensic record does not prove Joe McCann killed Ashlee Jenae. I have not stated that. This video does not assert it. What the forensic record proves is this: the conclusion that Ashlee Jenae died by suicide was reached before the evidence required to sustain that conclusion was complete. The person present at the time of her death has provided no factual account of the events. The evidence that could validate or invalidate the official ruling is either missing, sealed, or controlled by a single investigating authority with no independent oversight. Cleared is a word. The forensic record is a data set. And right now, those two things do not align. If you've made it this far, I need you to do something. Subscribe to Crime Case Analyst. Turn on notifications. Because this case is not over, and the next development could rewrite everything we think we know. This has been a forensic breakdown of the Ashlee Jenae case. The investigation may be officially closed, but the questions are still open, and we'll be here when the answers finally come. There is a question that surfaces in every comment section, every Reddit thread, every discussion about this case. It takes different forms, but it is the same question. Has this ever happened before? Someone walks free, no charges, and then years later, they're arrested. The answer is yes, and the frequency with which the answer is yes should change how you interpret the phrase "no charges at this time." Let me move through the comparative record. Not to argue that McCann will be charged, to establish that no charges in the immediate aftermath of a death investigation is a legal snapshot, not a final verdict, and that the interval between a death and charges in cases where the initial jurisdiction failed to act can be measured in years. Case 1. Kate Prout, Gloucestershire, England, 2007. Kate disappeared from the farm she shared with her husband, Prout. He reported her missing. Police investigated. No body was found. No charges were filed. Prout was interviewed and released. The case went cold. 2 years later, in 2009, Prout confessed to a prison cellmate that he had killed Kate. He was convicted of murder in 2010. 3 years from death to conviction, 0 years of charges. Then a confession broke the case open. The initial no charges was not exoneration. It was insufficiency of evidence at the time, a condition that changed when new evidence emerged. Case 2. Drew Peterson, Bolingbrook, Illinois, 2004. Peterson's third wife, Kathleen Savio, was found dead in a dry bathtub. The initial ruling was accidental drowning. Peterson was a police sergeant. The investigation was conducted by his own department. No charges were filed. The case was closed. 3 years later, Peterson's fourth wife, Stacey Peterson, disappeared. The pattern forced a re-examination. Savio's body was exhumed. A second autopsy found the death was consistent with homicide. Peterson was charged with Savio's murder in 2009, 5 years after her death. He was convicted in 2012, 8 years from death to conviction. The initial ruling, accidental, was not a conclusion, it was a failure. And the failure persisted until external pressure produced the second investigation. Case 3. The case most directly parallel to Ashlee Jenae's. Shanquella Robinson, Cabo San Lucas, Mexico, October 2022. Shanquella travelled to Mexico with a group of friends for a birthday celebration. She was found dead in her villa. Mexican authorities initially described the death as the result of alcohol poisoning or natural causes. No charges were filed against anyone in the group. The group returned to the United States. Then a video surfaced. The video showed Shanquella being physically attacked by one of the individuals in the villa, a person who had already returned to the United States without charges. The Mexican Attorney General's office issued an arrest warrant for the individual seen in the video. The FBI opened an investigation. The initial cause of death ruling was changed from natural causes to femicide. The individual was never extradited. As of this recording, no one has been charged in the United States. But the critical difference between the initial no charges and the subsequent arrest warrant is a single piece of evidence, the video, that the first investigation either did not have or did not examine. I want you to understand what these cases prove forensically. They do not prove that McCann will be charged. They prove that the absence of charges in the immediate aftermath of a death is a function of available evidence, not a function of innocence, and that when the evidence changes, the legal status changes, sometimes after months, sometimes after years. Sometimes after a jurisdiction that initially controlled the investigation loses that control to an authority with different incentives and different access. Now consider what this means for Ashlee Jenae's case specifically. The evidence that could change the legal status of every person questioned in this case is currently sealed inside the Zanzibar's surveillance system, inside Zanzibari police evidence lockers, and inside Ashlee Jenae's phone, if that phone still exists. None of it has been examined by any independent authority. None of it has been made available to the FBI, if the FBI is indeed involved, which has not been publicly confirmed. None of it has been produced in response to the family's documented requests. If any of this evidence is preserved, if the surveillance footage has not been overwritten, if the phone has not been destroyed, if the staff statements were recorded in writing and not just conducted orally, then the evidence exists to reopen this investigation under a different jurisdiction with a different incentive structure. If any of this evidence has been destroyed, overwritten, or lost, then the same jurisdiction that issued a ruling before its own forensic examinations were complete will have permitted the destruction of the evidence that could have contradicted that ruling. And that destruction, whether negligent or deliberate, produces the same forensic outcome, a case that cannot be reconstructed because the materials required for reconstruction no longer exist. I want to sit with that for a moment. A police force that rules a death a suicide before completing its own autopsy. A resort that does not preserve the scene before the body is moved. A jurisdiction that controls all evidence and releases none of it. A victim whose phone, belongings and engagement ring are not returned to her family. A suspect whose attorney promises more to say at the appropriate time, but says nothing about what happened on the night in question. These are not the conditions of a closed case. These are the conditions of a case that has been engineered for closure, where closure is not the same as resolution, and where the difference between those two words is measured in evidence that has been controlled, delayed, or permitted to degrade beyond forensic utility. There is a second dimension to the no charges question that extends beyond whether charges might eventually be filed, and it is the dimension that no other channel covering this case has addressed. What happens if charges are filed and McCann is no longer in Tanzania? The answer depends on a legal mechanism that most people have heard of, but few understand operationally: extradition. And the mechanics of extradition between Tanzania and the United States reveal a structural asymmetry that benefits the person who has already left the jurisdiction. The United States and Tanzania do not have a bilateral extradition treaty. This is a fact that is rarely mentioned in coverage of this case, and its significance is substantial. In the absence of a bilateral treaty, extradition between the two countries operates under the framework of international comity, a diplomatic courtesy, not a legal obligation. Tanzania can request that the United States surrender an individual. The United States can comply or decline. There is no judicial mechanism to compel compliance. If Zanzibari authorities were to file charges against Joe McCann tomorrow, they would need to submit an extradition request through the Tanzanian Ministry of Foreign Affairs to the US State Department. The State Department would review the request for legal sufficiency, determining whether the charges describe conduct that would be criminal under US law, whether the evidence presented meets the standard for probable cause, and whether the request complies with applicable treaties and diplomatic protocols. But here is where the jurisdictional trap tightens. The evidence that Zanzibar would need to present to support an extradition request is the same evidence that has not been released to any independent authority. The surveillance footage, the autopsy report, the staff statements, the victim's phone data, the physical evidence from the scene, if any was collected and preserved. If Zanzibar presents this evidence to the State Department, it becomes available to the US government for independent evaluation, which means the evidence that Zanzibar has controlled exclusively since April 9th would be exposed to scrutiny from a jurisdiction that has no economic incentive to maintain the suicide ruling. This creates a paradox. If Zanzibar files charges and seeks extradition, they must hand over their evidence to a government that may reach a different conclusion. If Zanzibar does not file charges, they maintain exclusive control of the evidence, but produce no accountability for the death of an American citizen on their soil. The strategic calculus for the Zanzibari government is straightforward. Filing charges risks economic damage. A high-profile homicide trial at a luxury resort generates international attention that deters tourism. Filing charges also risks evidentiary exposure, handing over evidence to US authorities who may find the investigation was conducted improperly, the scene was not preserved, and the ruling was premature. Not filing charges preserves the narrative, protects the tourism economy, and maintains evidence control. The cost of not filing charges is the ongoing public pressure from the family and media attention. But public pressure has a half-life. Tourism revenue does not. I am not stating that Zanzibar will not file charges. I am observing that the incentive structure of the jurisdiction creates a default position of inaction, and that overcoming that default requires either internal institutional courage or external pressure sufficient to make inaction more costly than action. Now, there is one more thread, and it is the thread that connects everything we have examined in this video back to the central question of what cleared means. McCann's attorney stated that his client was questioned as a witness, not a suspect. The distinction between witness and suspect is not cosmetic. In most legal systems, a witness has no right to remain silent during questioning, or more precisely, the exercise of that right carries different legal consequences. A suspect has the right against self-incrimination. A witness can be compelled to answer questions with the understanding that those answers cannot be used against them in a later prosecution if they are later identified as a suspect. But here is the forensic consideration. Classifying someone as a witness rather than a suspect at the initial questioning stage serves two functions. The first is procedural. It allows investigators to question the individual without the procedural protections that attach to suspect status. The second is strategic. It produces a public narrative that the individual was only a witness, which is then reported by media as not a suspect, and subsequently interpreted by the public as cleared. This is the chain of linguistic transformation that produces the false conclusion. Witness, not a suspect means not involved means cleared. Each step in this chain is a logical error. Witness status is an investigative classification at a point in time, not an evidentiary conclusion. A person questioned as a witness on day 1 can be reclassified as a suspect on day 100 if the evidence warrants it. The initial classification does not constrain the investigation's future direction, and the evidence that could trigger reclassification, the surveillance footage, the autopsy, the phone data, the staff statements, the foreign friends account, is currently sealed inside a jurisdiction that has demonstrated no urgency to complete its own forensic examinations before issuing conclusions. So when you read the headline, "Joe McCann cleared, no charges," you are reading a statement that conflates three distinct categories. Legal status, not charged. Evidentiary status, undetermined. Forensic status, gaps unresolved. The headline is accurate about the first. It is silent about the second and the third. And in a case where the second and third categories contain the information that determines whether the first category remains accurate, that silence is not neutrality. It is a narrative construction, one that serves the interests of everyone involved except the person who cannot speak. Ashlee Jenae cannot ask for the surveillance footage. She cannot request the autopsy report. She cannot demand the return of her phone. She cannot challenge the jurisdiction that controls the evidence. She cannot refute the statement that describes her death as a loss and her fiancé as relieved to be home. The forensic record speaks for those who cannot speak for themselves, but only if the record exists, only if it is complete, only if it is accessible, and only if someone examines it with the rigour that the people controlling it have not demonstrated. This is not a recap. This is a reconstruction of what the public record supports and what it does not. And the public record supports this conclusion: Joe McCann has not been cleared. Joe McCann has been released. And the distance between those two words is the distance between a jurisdiction that has closed a case and a forensic record that remains open. That distance is where this case lives. That distance is where the next development will land. And when it lands, the 7 evidentiary gaps we have catalogued will either be filled or they will have been destroyed by the same entities that produced a ruling before the evidence required to sustain it existed. The forensic record does not forget, but it can be erased, and the erasure of evidence is itself evidence of a system that chose closure over truth, and of a jurisdiction that will answer for that choice only if someone with the authority and the will to do so demands the answers that Ashlee Jenae's family is still waiting to receive. We will be here when those answers come, and if they do not come, we will be here to document their absence, because absence in forensic analysis is not nothing. Absence is a signal, and this signal is deafening. This has been Crime Case Analyst.